Welcome to the 24 Old Buildings Commercial Law Conference, London Conference. It's absolutely lovely to see you all here, and I'm sure you all must be thinking, what a relief to have some actual physical conference after all the months that we've had on Zoom and Teams, which I'm sure we're all have got absolutely sick of, though it does have a convenience. It's been just over 2 years since 24 Old Buildings had its last actual physical conference. So it's really great to be back, and it's lovely, as I said, to see you all. We've got, I think, a very exciting programme for you. If any of you have looked at it, you might think it's a little bit eclectic, because none of the subjects seem to have much connection. But there is a connection, and you've probably guessed it. The connection is that all of them are dealing with the most up-to-date authorities, almost all decided during the pandemic, all decided after virtual hearings, and all of them, I think, involving members of 24 Old Buildings. Now, I won't say anything more because we're running a bit late, but the first topic is one which I think you'll all think is very, very typical after the months and months that we've had of lockdown, a subject that you've probably all been thinking about during lockdown. It's entitled Unpicking Deadlocked Companies, and it's going to be given by Daniel Warents and Sparsh Garg.
Thank you, Alan, and good afternoon, everybody. It's certainly a relief to me at the start of this talk not to have to turn my camera on or spend 5 minutes making sure I'm not still on mute. So welcome to all of you to this in-person conference where ideas and, let's be honest, a fair few germs will flow freely. This is a talk about what to do when shareholders fall out. Now, those of you who advise regularly on shareholder disputes will be very familiar with the unfair prejudice relief provisions in Section 994 of the Companies Act. But we're not here today just to talk about unfair prejudice relief. We're also going to talk about the slightly less well-known weapon in the armoury of the disgruntled minority shareholder, namely winding up under the just and equitable clause. And in particular, what we're going to talk about is the deadlock ground for winding up companies under that clause, the modern incarnation of which is now in Section 122(1)(g) of the Insolvency Act 1986. Now, deadlock was a concept first recognised by courts dealing with company disputes going back to the 1890s and further developed in the course of the early 20th century. And it initially provided a judicial justification for bringing to an end dysfunctional corporate relationships by the appointment of a liquidator to wind up a company. I wouldn't say it's exactly fallen into disuse, but over the past 40 years, it's perhaps been slightly less popular since the reforms that came in 1980, which liberalised unfair prejudice relief. But the premise of our talk today is that there are going to be situations where it's worthwhile considering the deadlock ground and just and equitable winding up relief as a potential alternative to unfair prejudice, because there are situations where it can be a much more effective tool or potentially cover more ground than unfair prejudice relief would. But one problem traditionally with the deadlock ground of just and equitable winding up is that even in its heyday, when it was the more popular form of remedy, it was very difficult to pin down what was actually meant by deadlock. And it's fair to say that the old cases don't exactly speak with one voice on that subject. Some of the cases seem to envisage that it was about whether the company couldn't function at all, couldn't make any business decisions. Others focused on whether the relationship between the shareholders had broken down, even if the company and its business were still operational and viable, sometimes very profitable. But now, the law in this area has helpfully been clarified by a very lucid recent decision of the Privy Council in which, I'm pleased to say, Sparsh and I were involved although we don't mention it very often because, like most barristers, we're extremely modest and we don't like to talk about our successes very much. I think I'm contractually obliged, at least if I was putting this on LinkedIn, to say #humblebrag at this point. So the case which sorted it all out, or so we think, is called Chu and Lau. And as the trial judge in that case perceptively noted, in some ways the case was more like the breakdown of a marriage than the breakdown of a business relationship. Our story in Chu and Lau begins in the mid-1990s in the romantic setting of an international ship chartering business based in Hong Kong. It's there that Mr. Lau and Mr. Chu first met. It wasn't long before they became close friends, and they even started calling each other by pet names. Together, Mr. Chu and Mr. Lau set up a series of business ventures through a string of corporate vehicles. One of those businesses was a BVI company called Ocean Sino. Mr. Chu and Mr. Lau were 50-50 shareholders in that company. Ocean Sino had a wholly owned Hong Kong subsidiary called PBM, and PBM in turn owned 49% of a shipping and logistics company called Beibu Gulf, with the other 51% of that enterprise being owned by a Chinese state-owned business. The initial plan was for Beibu Gulf to purchase 8 ships using funds provided by the respective shareholders in Beibu Gulf, including ultimately Mr. Chu and Mr. Lau. And there was a shareholders' agreement at the Beibu Gulf level which obliged the shareholders in Beibu Gulf to provide what were described in the document as loans to purchase the ships. Mr. Lau and Mr. Chu duly provided the money, approximately $40 million in total, through Ocean Sino and PBM, by these loans into Beibu Gulf. But in the end, for various reasons, only 4 ships were ever purchased by Beibu Gulf. And once it became clear that the money wasn't all needed to buy ships, Mr. Lau said to Mr. Chu that he wanted PBM to recall some of the money back in repayment of the loan. However, Mr. Chu didn't want the loans to be repaid. In fact, he insisted the loans weren't loans at all, but capital contributions to Beibu Gulf. And this seemingly innocuous dispute ultimately led to the destruction of their entire business relationship. And they ended up commencing numerous pieces of litigation against each other in Hong Kong and BVI relating to their various joint business ventures. Board meetings would be called at short notice while Mr. Lau was abroad, or Mr. Chu would refuse to hold meetings entirely when requested by Mr. Lau. And when board meetings did take place, they were farcical. Mr. Chu would deliberately speak in Mandarin, knowing that Mr. Lau only spoke Cantonese. And after the meetings, there was no consensus as to what had happened at the meeting or whether anything at all had been agreed. Mr. Lau petitioned the BVI court for the winding up of Ocean Sino on the deadlock ground. Mr. Chu opposed the petition, arguing somewhat incredibly in the circumstances that despite their differences, his relationship with Mr. Lau had not in fact irretrievably broken down. Mr. Lau won at trial at first instance and obtained a winding up order. But the Court of Appeal set that order aside. So what did the Privy Council do, Sparsh?
Well, Daniel, the Privy Council agreed with the trial judge and held that Ocean Sino should be wound up, and found that there was a deadlock between Mr. Chu and Mr. Lau. Lord Briggs clarified that there are in reality 2 types of deadlock. Those 2 types are distinct, he said, but they're also related. And in circumstances such as in the case itself, the 2 may overlap. The first is what can be described as a functional deadlock. Now, this is quite simple. It's not dependent on the characteristics of a company or the personal relationship between the shareholders. It arises where there is a disagreement between the shareholders. There's no available mechanism in the company's corporate documents for meaningful company decisions to be made. A simple case is where one set of shareholders vote in one direction, another set vote in another direction, and there is no way to break the deadlock. We then come on to the second type of deadlock, an irretrievable breakdown in the relationship of trust and confidence between the shareholders. A breakdown in relations had already been a ground for dissolving a partnership since the mid-19th century. That analogy was extended to companies. But a breakdown in relations doesn't always justify winding up a company. In particular, the petitioner first needs to establish that the relationship between them and the respondent is one of mutual trust and confidence. Well, when does that relationship arise? The shorthand term is when there is a corporate quasi-partnership, and that arises typically when the company comprises of one or more of three elements. One, an association formed or continued on the basis of a personal relationship between the shareholders. Two, an agreement or understanding that the shareholders will participate in the conduct of the business. And three, if there is a restriction upon the transfer of the shareholders' interests in the company. It's not necessary for all these elements to be present in the company to be described as a quasi-partnership. Indeed, the Privy Council in Lau and Chu was very clear on that. But in the absence of a finding of a corporate quasi-partnership, the irretrievable breakdown ground will not be available to a petitioning shareholder. So, on the one hand, the irretrievable breakdown ground only applies to a finite number of companies, corporate quasi-partnerships. On the other hand, it's potentially broader than the functional deadlock ground. An actionable irretrievable breakdown can arise as a result of many factors that are completely divorced from the company's affairs. The earliest example of this is a South African case called Warents and Larich Motors. This case involved two shareholders. One shareholder had an affair with the spouse of the other. That other shareholder himself had numerous affairs across Johannesburg. Apparently, it was effectively a 1940s version of Love Island or Bachelor in Paradise, depending on, take your pick, I suppose. But the court, not surprisingly, found that the business partners could not possibly carry on business together and wound the company up. The other aspect of the irretrievable breakdown ground, as opposed to a functional deadlock ground, is that you have a slightly lower threshold, potentially, to overcome. Whereas in the functional deadlock ground, the company has to stop functioning, as it says on the tin, as a result of the deadlock. That is not a requirement on the irretrievable breakdown ground. Indeed, the company could well be prospering, could be doing quite well. However, what is important is that there has been a breakdown in the relationship. So, leaving deadlock to one side, we move on to the second part of our talk. That's the relationship between just and equitable winding ups and unfair prejudice petitions, and the factors to take into account in deciding what remedy to pursue. Now, there's obviously considerable overlap between the two, but just a couple of differences to bear in mind. One is that the shareholder can only petition for a just and equitable winding up in respect of a solvent company. There's no such requirement with respect to an insolvent company. The second difference to bear in mind is that a just and equitable winding up petition, like any other winding up petition, is subject to the requirements of Section 127 of the Insolvency Act 1986. That means that any dispositions of a company's property between the presentation of a petition and the making of a winding up order need to be subject to a validation order by the court. There's no such requirement with respect to there's no such restriction, rather, with respect to unfair prejudice petitions. I think we're now going to come on to the substance of, between the relationship. And Daniel, over to you.
So, as Sparsh says, there's obviously room for considerable overlap between unfair prejudice and the deadlock ground for winding up. Both can clearly arise on the same facts. But if there is one important point to take away from today's talk, it's this, that the overlap is not complete. They're more like Venn diagrams than concentric circles. As Lord Briggs put it neatly in Chu and Lau, it's not likely to be assumed that an applicant who can prove the latter will equally be able to prove the former. So in many ways, the deadlock ground for winding up is in fact significantly broader than unfair prejudice, and potentially much easier to establish. So first, unlike in an unfair prejudice case, the petitioner does not need to prove that he or she has suffered prejudice in their capacity as a member of the company. All that needs to be established is that there is either a functional deadlock in the sense Sparsh has described, or an irretrievable breakdown in a relationship that was previously characterized by trust and confidence. Once that state of affairs is proven, it's not necessary for the court to consider whether there's any additional element of prejudice. The state of affairs of deadlock in either of those two senses is sufficient. By contrast, prejudice in a capacity as a member is an essential element of any claim for unfair prejudice relief. Secondly, at least in a quasi-partnership irretrievable breakdown case of deadlock, in considering whether the relationship between the members has broken down, the court can properly consider any facts relevant to the breakdown of that relationship, whether or not it is concerned directly or otherwise with the operation of the company. So, as Sparsh mentioned in that case, the South African case earlier, if there's been a personal falling out over the romantic affairs between the different members that's not directly related to anything to do with running the company or business affairs of the company, that can be sufficient so long as the relationship has in fact broken down to justify winding up the company. By contrast, the same act would not constitute unfair prejudice for the purposes of Section 994. The third difference is that once the existence of the relevant state of deadlock has been established, the winding up jurisdiction is properly engaged even if none of the shareholders has done anything wrong. Therefore, in principle, deadlock is a potential route to what's been described as a no-fault divorce between shareholders in a company. By contrast, ever since the House of Lords decided O'Neill and Phillips, it's been clear that the court will not allow a no-fault divorce in unfair prejudice cases. In other words, the petitioner must always show that the respondent shareholder has done something wrong in relation to the conduct of the affairs of the company before unfair prejudice relief will be available. In practice, this means that a petitioner seeking unfair prejudice relief must plead and prove either a breach of duty or a breach of the company's corporate governing documents, or a breach of a shareholders' agreement by the respondent. So classic examples of that are breaches of directors' duties or misappropriation of the company's assets by one of the shareholders or such like. Or secondly, conduct which, although not necessarily a breach of the petitioner's strict legal rights, nonetheless involves conduct which equity would regard as contrary to good faith. And the classic example of that is where, in a quasi-partnership company, a minority shareholder is excluded from the management of the company, contrary to the a previous understanding between the quasi-partners. And in the unfair prejudice context, as I mentioned earlier, the petitioner must also show that the prejudice that they have suffered was in their capacity as a member of the company. So suffering prejudice in a different capacity, such as an employee of the company or as a creditor of the company, will be insufficient in the case of someone seeking to invoke the unfair prejudice machinery. But no such technical limitations apply to winding up on the deadlock ground. Nonetheless, there will be many cases where deadlock and unfair prejudice arise on the same facts. For example, where one of the shareholders has stolen money from a quasi-partnership company, and this has understandably resulted in the breakdown of the relationship between the members, the jurisdiction to grant unfair prejudice relief is very likely to be engaged at the same time as the winding up jurisdiction. Where there is such an overlap, so that both jurisdictions are engaged, generally speaking, unfair prejudice relief is likely to be more appropriate since it's a more flexible remedy than just winding the whole company up. Indeed, under Section 125(2) of the Insolvency Act, the court is actually precluded from ordering a winding up where the court is of the opinion that some other remedy is available to the petitioner and that the petitioner is acting unreasonably in not pursuing that other remedy. However, a respondent who wants to argue that the petitioner should be pursuing some other remedy ought to raise it at an early stage by way of an application to stay or strike out the winding up petition. It's not a point that the respondent is entitled to keep up their sleeve until trial. On top of that, if the respondent seeks to argue that unfair prejudice relief is more appropriate than winding up, the respondent may find that they are put to their election as to whether or not they admit that there are grounds for granting unfair prejudice relief, as otherwise the petitioner can hardly be blamed for wanting to take their winding up petition to trial in case they don't succeed in establishing their unfair prejudice case. Now, I know that there are copious amounts of hand sanitizer around this hall, which is probably appropriate because at this point I'm going to hand over to Sparsh, who's going to tell you about clean hands.
Yeah. Well, thanks, Daniel. Well, it is government advice to wash your hands quite regularly. Now, in a relationship, it takes two to tango. And like in any relationship, I mean, ask Amber and Greg from Love Island 2019, both parties usually take a share of the blame. The same was also found to be the case by the trial judge in Chu and Lau. But just because the petitioner may have been partly to blame for the breakdown does not justify refusing a winding up order. As now Supreme Court Justice Lady Rose said in a case in 2014, if you were to refuse relief on this ground, you'd be ignoring the very realities of human relationships. So the courts therefore have stated that the petitioner must be the sole cause for the deadlock in order for relief to be refused on the basis of the petitioner's so-called unclean hands. Although, having said that, it's worth bearing in mind a very recent judgment on this topic from the summer, Il and Yesel Kaya. In this case, there had been a catastrophic loss of trust and confidence between the shareholders, and both parties were found to be at blame. But the court refused to make the winding up order. It held that it would be inequitable and unjust to do so in circumstances where the petitioner was found to have deliberately sought to strip the company of its business and wrote misleading correspondence to his quasi-partner. So it is possible that a petitioner's misconduct, if particularly egregious, may still be taken into account in refusing to making up a winding up order, even if that person is not the sole cause for the deadlock. In the unfair prejudice context, the courts have taken a similarly limited view of when misconduct may deprive a petitioner of unfair prejudice relief. The courts have said there is no requirement for a petitioner to have clean hands. However, if the misconduct is sufficiently serious and closely connected to the unfairly prejudicial conduct of the respondent, then it may either mean that the respondent's conduct is not unfair or affect the remedy the petitioner seeks. For example, the court may value the petitioner's shares at a lower price for the purposes of share purchase order than may otherwise be the case. But I'm touching on remedies, which Daniel is going to tell you more about.
Yes. So it's important to bear in mind that in many ways winding up a company is a very extreme remedy in that it brings the entire company and its business to an end. By comparison, unfair prejudice relief, as I mentioned earlier, is much more flexible and usually less drastic, normally involving one shareholder or the other being ordered to buy the other member out for a fair price, so that the company's business in that situation can probably continue on as before, unaffected. As I mentioned earlier on, if the court is satisfied that some alternative remedy to winding up, including unfair prejudice relief, is available to the petitioner, and the petitioner is acting unreasonably in not pursuing that remedy, then that is a ground in and of itself for refusing to wind up the company. That having been said, if the respondent wants to rely on that kind of argument, then the legal and evidential burden is on the respondent to prove both that A, there is another available remedy for the petitioner, and B, that the petitioner is acting unreasonably in nonetheless seeking a winding up order. That was one major point of dispute in Chu and Lau, because Mr. Chu sought to argue that the burden was actually on Mr. Lau to prove the negative, so that Mr. Lau had to sort of come up with a complete list of every conceivable alternative remedy there could be and disprove it before Mr. Chu had to do anything. And not surprisingly, the board rejected that argument and said, look, in practical terms, if you're going to say as a respondent there's an alternative remedy, the burden is on you to identify that remedy and put forward a proper evidential basis to show that that is the one that ought reasonably to be pursued. And another important point on alternative remedy is it's not sufficient to show that another remedy might theoretically exist. What must be shown is that the alternative remedy that's been identified is sufficiently attractive to the petitioner so as to make it unreasonable for the petitioner to seek a winding up instead of that alternative remedy. Now, in Chu and Lau itself, a number of reasons were given why Mr. Chu's suggested alternative remedies in that case were not sufficiently attractive, which may in future cases be of general application. And I'm just going to whiz through these as we're probably a little behind time. But essentially, one likely relevant factor is where there is a need for the company's affairs to be investigated by a liquidator, particularly in situations where there's been allegations of misconduct or misappropriation of the company's assets, that is likely to be a situation where the appointment of a liquidator will be justified as a better alternative to unfair prejudice relief. Secondly, where the respondent shareholder may not have the means or inclination to buy the petitioner out, that will be a reason to consider that unfair prejudice relief and a buyout order is not a practical way forward. Third, and related to the first point, it may be impossible or near impossible for the court to properly value a company in misappropriation cases or situations where the company's affairs otherwise require investigation due to a lack of information, which was one of the problems in Chu and Lau, which pointed in favour of appointing a liquidator. Another point in favour of appointing a liquidator is if whatever unfair prejudice relief may be granted, it won't, or other relief that may be sought, it wouldn't bring an end to the litigation. In Chu and Lau, it was suggested that what Mr. Lau should have done is brought double derivative claims, or in either BVI or Hong Kong, which would have been years more of litigation, whereas Mr. Lau quite reasonably wanted the liquidator to investigate and bring such claims on behalf of Ocean Sino as might be appropriate. And that point has been followed in a relatively recent case in Dairid and Sea Island Realities Limited, where the court, considering Chu and Lau, found that a sale was not viable given the perennial state of the company's indebtedness. And a final point on this issue is that the court cannot make a share purchase order on a just and equitable winding up petition. The only order that can be made by way of relief at the end of the case is to order the winding up of the company, which is to be contrasted with the position in Cayman, where once you prove the grounds for winding up, it opens the door to essentially the wider unfair prejudice remedies.
I'm just going to make 2 points about the unfair prejudice remedies. One, there's a range of remedies available, but the one remedy that isn't available is a winding up order. But you have everything else, well, within reason, I suppose. And then shortly, to conclude, we've produced a table which we thought may be useful in deciding which remedy a shareholder may want to pursue. I think it's just 4 short points to bear in mind. 1, can you realistically establish fault on behalf of the other shareholder? 2, does your dispute relate properly to the affairs of the company? 3, are protracted liquidators' investigations going to get you anywhere? And 4, the final point, do the parties have the resources to buy each other out? That's all from us. Thank you for listening.
Well, thank you both very much. Could I just say that if there's time at the end, I'll try and allow any questions, but I don't think we're going to have time for questions in between. But hold up your questions, because there may be some from that which you'll want to raise. Well, our next talk, given by Timothy Sherwin, has a title that sends shivers, certainly as far as I'm concerned, up any litigator: Claim Forms, Complaints and Catastrophes.
Thanks very much, Helen. We'll recognise, I think, hopefully some of the pictures. Claim form, most of us will recognise. I've not received one myself, thank God. 24 Old Buildings. It's great to see you all in person. This, of course, is a catastrophe curve. So you can tell me later over drinks where on the catastrophe curve this talk ends up. So this is what I'm going to talk about really quickly. Insolvency proceedings and the cure-all of Rule 3.10. Pleading and proving fraud, and I'm going to try and derive from some recent cases some principles for the court's most recent approach in ending litigation quickly. So, Taunton Logs Limited, a decision at the end of last year. I'm even more modest, if you can believe it, than Daniel and Sparsh, because while this was a case I was involved in, I lost. Now, Insolvency Act applications only apply to claims brought under Parts 1 to 11 of the 1986, that should be, Act. That's what was decided in Taunton Logs Limited. Taunton Logs Limited was a case where a liquidator was trying to bring a debt claim. He said that the former contributories hadn't paid up when they bought their shares and they wanted the money. And they did it by Insolvency Act application notice. Can you do that? Well, they said, yes, of course we can. We're liquidators. It's an Insolvency Act application. And we said, no, you can't do that. And we won on that point, but we wanted more because they'd brought the Insolvency Act application 2 days before the limitation deadline, and we applied to strike them out on the basis that actually they should have brought a Part 7 claim and then limitation had expired before they did so. They didn't pay the £10,000 issue fee. What did the judge do? Well, he said, yes, you're right. You can't bring this by Insolvency Act application notice, but you can pay the £10,000 issue fee, and I'm going to cure it under Rule 3.10. Where there has been an error of procedure, such as a failure to comply with the rule or practice direction, the court may make an order to rectify the error. Now, the big problem here, and the thing that I think is really striking about this case, is an Insolvency Act application notice isn't a claim form. It's just a piece of paper. And that was my argument in this case. If you go around issuing pieces of paper and stamping them with court seals, does that mean that the court can just convert that into a claim form if it later wants to? Now, the judge in this case said yes, and there was some previous authority, although this wasn't actually cited to the judge. This is Mr. Justice Lightman in a 2001 decision. I have the power, he says, to treat the originating application as a claim form, giving no authority or reasons why he said that. But that's where we get to on Rule 3.10. So an incredibly powerful resource if we can find some reasoned basis for adopting it. And what is useful is that in Manolete Partners, another case, this time a misfeasance claim by an assignee, so a liquidator's assigned a claim to Manolete Partners and they brought the claim, and it was argued that they had to use a Part 7 claim form, and the judge agreed. But he said that where there's an abuse, it won't be converted to Part 7, and if you don't pay the £10,000 issue fee, that is an abuse, but it can be cured simply by paying the £10,000 issue fee. Great. You can have a go. If you get it wrong, pay your issue fee and move on. Now, that sort of liberalness, if I can put it that way, is definitely not present in the fraud cases. And we see this in the King and Stifle decision. Now, this is an absolutely extraordinary judgment. I mean, if you have a bit of time, definitely read it, because it's a proper roller coaster. Mrs. Justice Cockerill, very much in combative form. And she said this about the pleading: it's unclear in the extreme and combines tendentiousness with a combination of oversupply of evidence and undersupply of proper particulars. I think she didn't like it. She struck out the claim and she granted summary judgment. And the real problem here was that, as she pointed out, one of the key functions of a statement of claim, as well as telling the other side what your case is, and as well as confining the issues, i.e. identifying those issues where there is actual agreement and you don't need to go to trial, it's also meant to be a checklist for you as the claimant. Do I have a cause of action? And the judge said they'd totally lost sight of this. The claimant had totally lost sight of this in that case. It simply had forgotten or omitted to plead causation and to plead knowledge for the ground of fraud. So she struck out the claim. Great. Now, she made some really useful postscript points, and I think these are really good for bearing in mind, both for claimants in fraud proceedings, but also, of course, in defendants. Don't make specific allegations which lack basis. Don't leap from thinking the worst to pleading allegations of fraud. If you need to give full and frank disclosure, just give it. It's much better to be upfront than have to come back later. And don't make routine accusations of impropriety. This was one of those cases where everything that happened, the claimant's lawyers would say, aha, you would say that, wouldn't you? More proof that you are crooks. Don't do it. And I think that's really useful, both from the point of view of your claimant's checklist, but also from the point of view of your defendant. Is this what the claimant's doing? So, we also have a really interesting line of recent decisions about trying to set aside judgments for fraud, where a claimant, having lost a claim, has later come back to say, I can set aside that judgment for fraud because there was a material dishonesty. And that Takar and Gracefield Developments Limited, that's the first instance decision after it was remitted by the Supreme Court. And the claimant won in that case. That's created an absolute deluge of more recent cases. Dale and Banger in the Court of Appeal failed, Jeffrey and Jeffrey at first instance failed, and Axon Limited and O'Keefe also failed at first instance. But the thing that all those cases have in common is that the allegation of dishonesty was not material to the decision at first instance. It wasn't causative of any loss. So what can we try and draw together from these disparate streams of recent knockout case law? Well, obviously, is there a coherently pleaded case? Mrs. Justice Cockerill says it should be a checklist for you as a claimant to make sure that your claim makes sense. 2, is fraud actually raised? And if it is raised, have the enhanced pleading requirements been met? Recent Court of Appeal decision in SOFA and Swiss Independent Trustee gives a nice list of what the pleading requirements of fraud. But I think the difference between Taunton Logs, which was a debt claim, and King and Stifle is a lot of it was really about the enhanced fraud requirements. If you're going to make these very serious allegations, you have to have a pretty good argument. Whereas on a debt claim, let's find out. Is there any abuse and is it easily curable? Can you just pay the £10,000 issue fee and everybody moves on? Is there actually a knockout point, such as causation or limitation, that the court can grapple with easily and cleanly without having to get into the facts? And finally, and I think this is particularly important in respect of those cases about setting aside judgments for fraud, what way does the principle of finality in litigation, which way does the principle of finality in litigation point? Because the court's always going to want to say there is a final, unappealed order, somebody's won, somebody's lost, the merits have already been tested, and we can bring it to an end. And that's what I'm going to do for my talk. Thank you very much.
Well, thank you very much. I'm sure my pleadings have been criticised judicially, but I don't think they've ever been criticised as much as that one was by Mrs. Justice Cockerill. And we're all heaving, or some of us, maybe someone in this room who isn't, heaving sigh of relief that they were the person who settled the pleadings or proved the pleadings in that case. Right, our next talk is by Elizabeth Weaver. Fascinating subject, which I know has been, certainly some years ago, the subject of considerable disagreement between Court of Appeal and the House of Lords. Limits on limitation, the law on deliberate concealment. Elizabeth.
Thank you, Alan, and hello, everybody. As Alan says, I'm going to look at the concept of deliberate concealment in the law of limitation, which you will see is not always the clean and easy strikeout point that Tim would like it to be. Now, I'm sure you all remember the conversation in Through the Looking Glass between Alice and Humpty Dumpty about the meaning of words, in which Alice says, the question is whether you can make words mean so many different things. Now, I don't know if Sir Robert McGarry had that exchange in mind when he made his well-known comment in Tito and Waddell about Section 26 of the Limitation Act 1939, which postponed the running of time in a case of concealed fraud. And what he said was, as the authorities stand, it can be said in the ordinary use of language that not only does fraud not mean fraud, but concealed does not mean concealed. It's now 20 years since the Limitation Act 1980 replaced Section 26 with Section 32 and the new concept of deliberate concealment. But over that time, it seems to me that history is repeating itself. Case law is complicating what ought to be the ordinary meaning of the words. And that trend has been taken further in the two recent Court of Appeal cases that I'm going to look at. And that's Canada Square Operations and Potter and OT Computers and Infineon Technologies. And I'm even more modest than my colleagues because I wasn't in either of the cases. If we start with the Canada Square case, it considered what's meant by deliberate concealment in Section 32. Now, the context was a claim by Mrs. Potter to recover a PPI policy premium of £3,834, which she had paid back in 2006. And most of that payment had been made up of commission paid to Canada Square. But the amount of the commission had not been disclosed to Mrs. Potter when she took out the loan. And it wasn't until 2014 that the Supreme Court decided that non-disclosure of commission in circumstances like Mrs. Potter's made the relationship between the borrower and the creditor unfair within the meaning of the Consumer Credit Act. And that allowed the court to order repayment of the premium if it thought it appropriate. So Mrs. Potter made her claim, she was met with a limitation defence, and she alleged deliberate concealment. And the significant point was that back in 2006, when she'd taken out the loan, there was no statutory provision, nor indeed even any FSA requirement that the commission be disclosed. Now, despite the House of Lords having said in the Cave, Johnson, Jarvis and Rolfe case that the language of Section 32 is clear, it's plain words, they need no embellishment, it took the Court of Appeal 201 paragraphs over 41 pages of judgment to decide the case in favour of Mrs. Potter. So where have we got to on deliberate concealment? Well, as you know, the requirement to prevent time running for Section 32(1)(b) is that any fact relevant to the claimant's cause of action has been deliberately concealed by the defendant, and that includes the defendant's agent. So if we start at the beginning, what has to be concealed? Well, it's any single fact. It doesn't have to be all the facts. But it must be a fact that's relevant to the right of action. And that's judged by the statement of case. Test. Established by those cases on the slide. In other words, is the fact an essential element of the claim? Is it something that needs to be pleaded as part of your cause of action? A potential claimant who knows all the essential facts can't rely on Section 32 to delay the running of time just because she hasn't got all the facts that would strengthen her case or she lacks a particular piece of evidence. Next question. What does concealment mean? Well, the Oxford English Dictionary, for what it's worth, means keeping something secret or hidden from knowledge. And that clearly covers active concealment. So let's look at, you could have making an untrue statement, destroying documents, covering up a defect in a building. Now, in the Cave case, Lord Millett had noted that concealment and non-disclosure are different concepts. And indeed, he referred in that case to active concealment being the natural sense of the words deliberate concealment. But despite that, two subsequent decisions of the Court of Appeal have held that non-disclosure can be concealment, provided the defendant was under some obligation to speak. In Williams, Fanshawe, Porter and Hazelhurst, the court held that there had been concealment by a solicitor who, in the course of an ongoing retainer, had not told his client about procedural mistakes which had resulted in the loss of her personal injury claim. The implied term of his retainer, that the client should be kept informed of the progress of the litigation, meant that his failure to speak amounted to concealment. In the Critty Palm case, the defendant was engaged by the claimant to test and certify a cargo of gasoline. Negligently, it used the wrong tests. When it realised, it retested, confirmed the certificate to this claimant, but without mentioning what had happened. And the Court of Appeal was split about whether that omission was concealment. Lord Justice Ricks said that in the absence of any express or implied contractual duty, there was no duty to speak and no concealment. But the majority held that in the circumstances, the defendant was under a sufficient duty to speak that its omission to mention the retesting was concealment. Unfortunately, the majority didn't elaborate on how that duty arose. And Lord Justice Buxton referred to the defendant as being under a duty to reveal in the sense relevant to the Limitation Act? You might well ask, yes. And unfortunately, the decision in Canada Square has not assisted in making that any clearer. It followed the Critty Palm in holding that it's not necessary to have a pre-existing contractual, tortious, or fiduciary duty to speak in order to make non-disclosure into concealment. All that is needed, to use the language of Lady Justice Rose as she then was, is some obligation to disclose arising from a combination of utility and morality. And in Canada Square itself, that was said to arise from the concept of the unfair relationship in the consumer credit legislation, which it was said put Canada Square under a duty to speak because otherwise the relationship would be unfair. So how do we apply this somewhat nebulous test in practice? It seems to me that the key has to be to look at, was there a relationship between the claimant, the potential claimant and potential defendant at the time of the alleged concealment? And if so, what was the nature of that relationship? In the Williams case, Mr. Justice Park in the Court of Appeal had referred to the defendant being in a relationship where a fact would normally be disclosed in the course of that relationship but was not disclosed. So it seems to me that if there's an ongoing relationship with some element of reliance or trust, non-disclosure of a fact that could be expected to be shared may be sufficient to constitute concealment. But on the other hand, if there's no longer any relationship between the parties, let's say there was a one-off conveyancing transaction, I'm not sure that if the solicitor doesn't respond to inquiries years later, that could be thought to be concealment. Bearing in mind, of course, that there's no general duty in English law on a wrongdoer to disclose the wrongdoing. Now, the second way that concealment can occur is deemed concealment under subsection 2. And that's where you have a deliberate, and we'll come back to what that means in a moment, but not merely negligent, commission of a breach of duty in circumstances in which it is unlikely to be discovered for some time. Such a breach of duty is treated as deliberate concealment of the facts involved in the breach. So it's an alternative way of proving that facts have been deliberately concealed. The Canada Square case confirms that breach of duty doesn't have to be the breach of a tortious, contractual, or fiduciary duty. It can be any legal wrongdoing actionable by an individual. So, for example, a transaction to defeat creditors under the Insolvency Act. Now, the last question that was considered by Canada Life is the mental state that's necessary for concealment to be deliberate. And I think this is where there's potential for the greatest expansion of the application of Section 32. Because whereas previous case law had talked in terms of intention to conceal, a conscious decision not to tell, knowingly breaching a duty, Canada Life decides that recklessness is sufficient for both limbs of Section 32. So a defendant will deliberately conceal a fact if he takes a risk that the fact he's not disclosing may be relevant to the claimant's cause of action, and if he takes a risk that he is in fact under a sufficient duty to disclose and doesn't do so, and it's unreasonable for him to take that risk. Section 32(2) will apply if the defendant takes a risk that he is committing a breach of duty and it's unreasonable for him to take that risk. Now, it's quite clear from the case that the court thought, and they may well be right on this, that the merits were all with Mrs. Potter. But in the context of Section 32, if we go back to Alice's question, it seems to me that the words deliberate concealment now means something very different to what you might think on first reading. The second case I want to mention is OT Computers and Infineon Technologies. That considers the question of when a claimant is treated as learning of concealed facts so as to start time running. Time starts to run when a claimant has or could, with reasonable diligence, have discovered the concealment. Now, there's something of a tension in that language between the subjective, it's got to be the actual claimant who has to discover, and the objective element of reasonable diligence. And so the courts have held that the personal characteristics of a claimant, such as naivety or financial inexperience or being ill-informed, are to be ignored. In asking what is involved in using reasonable diligence, the test laid down in Paragon Finance and Thacker is often applied, and that's how a person carrying on a business of the relevant kind would act if he or she had adequate but not unlimited staff and resources and was motivated by a reasonable but not excessive sense of urgency. In the OT Computers case, the company had ceased trading and gone into administration some time before information started to emerge that the defendant, who were suppliers of computer chips, had been involved in an illegal price-fixing cartel. Now, a computer manufacturer who was actively trading might well have picked up on that news and so have come under an obligation to investigate with reasonable diligence. But the news was of much less significance to the insolvency practitioner who was dealing with the administration, and he did nothing. Was that a failure to use reasonable diligence? Well, the Court of Appeal held that nothing in the language of Section 32 required it to disregard the fact of the insolvency or to assume that the claimant was someone or something that it was not. Lord Justice Mayles, who interestingly was also a member of the court in Canada Square, gave short shrift to the argument that this approach could expose a company in administration or liquidation to claims many years after the event. And he said it's not necessary to be too sympathetic to defendants who have deliberately concealed wrongdoing. So these two decisions represent, in my view, a definite shift in the court's approach to Section 32. Section 32 has to strike a balance, and that's a balance between the interests of defendants in not being exposed to stale claims and the interests of claimants who are unable to pursue legitimate claims. The combined effect of the decisions is, I think, to tip the balance in favour of claimants. But the question is, has it gone too far? It's a bit simplistic, I think, to say that defendants shouldn't have the benefit of the doubt, because any statute of limitations, by definition, protects people who may be wrongdoers. In Sheldon and Outhwaite, the House of Lords referred to the rationale of Section 32 as being operating in favour of a claimant who has been prevented from bringing a claim by unconscionable or dishonourable conduct by the defendant. And in Cave itself, Lord Millett had observed that in the absence of intentional wrongdoing, and I emphasise those words, it was neither just nor consistent with the purpose of the Limitation Act to expose a professional man to a negligence claim many years later, by which time he might have retired, ceased to be covered by insurance. And it seems to me arguable that the recent approach has not given sufficient weight to the concept that it has to be actual impropriety by the defendant, which is the underpinning for Section 32. I mean, it'll be interesting, therefore, to see what further refinements of the plain words of Section 32 will emerge as the courts grapple with this, I think, difficult concept of deliberate concealment. Thank you very much.
Thank you, Elizabeth. It seems we have a repeat here, 20 years later, of the conundrum that occurred where the Court of Appeal had rendered the section difficult to understand, and the House of Lords came in and gave in Jarvis to clarify what the section meant. So we all await, no doubt, a decision of the Supreme Court in due course to get the matter clear, if not right. Of course, it is right by definition. Right, the next one, here we go again, is a talk given by Hugh Miall. He'll explain what the issue is. Just to disclose conflicts of interest here, both Hugh and I more than Hugh because I was leading him, were the unsuccessful appellants in the case which I think he's going to refer to.
Thank you, Alan. Yes, good afternoon, and it's lovely to see so many of you here in person. Yes, I'm in the invidious position of talking about another case that we were not successful in, Alan and I, in the Court of Appeal, and at first instance on my own. I'm also putting myself slightly in the hot seat because not only do I have one of my instructing solicitors in the room, but I'm pretty sure we have the instructing solicitors from the other side here as well. So there's lots of people who can pull me up on various bits and bobs as we go through. As litigators, and particularly for those of us who are regularly involved in fraud litigation, one of the powerful legal weapons that we use to fight and to trace into and ultimately recover misappropriated assets is the ability to seek rescission of a contract or a transaction which has been induced by fraud. Now, the legal consequences of a successful rescission in such cases is, I think, relatively well traversed. The effect of the rescission is the equitable interest in the property revests, for want of a better expression, in the original owner. The revesting is retrospective insofar as it is treated as always having been the position, at least so far as is necessary to allow the victim to utilise the following and tracing rules and to allow them to assert a proprietary interest into the relevant property. But the retrospective action does not permit claims for breach of trust to arise in the period before the rescission occurred. And that is essentially, I think, to sort of paraphrase some academic argument, because legal and beneficial title passes at the point of the transaction, but the beneficial title is defeasible in the hands of subsequent recipients until defeated by a defence like bona fide purchaser for value without notice. And you come across phrases like the mere right of, or the mere equity of a right to set aside avoidable contract. The practical result would probably be the same, where the court determines the transaction or the contract is void, save that there are questions of whether the title moves at all. It is also, at least in my view, I think, relatively clear that remote recipients of assets disposed of under voidable contracts are vulnerable to proprietary claims, which are consequent on a successful rescission or setting aside of the contract or transaction, where the recipient has taken nothing more than the defeasible title conferred under the original transaction. So there's your obvious example of a bona fide purchaser for value without notice. A mere volunteer who has just simply taken the defeasible title is susceptible to a proprietary claim. So having established those sort of, I think, relatively uncontroversial principles, I wanted to introduce a complicating factor which is the focus of this talk and was the focus of the case in hand, which is to what extent an order of the court granting a claimant relief in a claim for rescission of a fraudulently induced contract or transaction against the only other parties to it can or has some legal effect against a third party who has received as a volunteer the property or its traceable proceeds. So to put it a different way, once you've successfully rescinded against the counterparty to the fraudulent transaction and obtained relief from the court, including in this case a declaration as to your beneficial title to the property, do you have to reprove the entire case against someone who is simply a recipient of that property later down the chain but has nothing to do with the transaction itself? And that is broadly, I've sort of oversimplified it, the issue which the Court of Appeal was asked to consider in Ward and Saville. And as far as I'm aware, this was the first case, I think at first instance, that we all agreed that there wasn't an authority dealing with it directly. So this is probably the authority that deals with it now. The facts broadly were these. The claimants participated in a tax scheme in which they were induced to pay several millions to certain limited liability partnerships controlled by certain individuals. Having discovered the scheme to be a fraud, the claimants commenced proceedings against the LLPs and the individuals controlling them and certain other connected parties, seeking various forms of relief, but including declaratory relief and the rescission of the transaction, that they had a beneficial interest in the monies paid to the LLPs. And that declaratory relief was granted in 2018. Now, the claimants contended that they could trace their money into a house which is now owned by the wife of one of the individuals who ran the scheme. She was not joined to the main proceedings, having contended that she would be deprived of a limitation defence to the proprietary claim against her. So the claimants commenced a fresh claim asserting a proprietary interest in that property. And in doing so, they sought to rely on the 2018 judgment and order as a basis for their asserted intentions. In her defence, the defendant did not challenge the 2018 judgment or order, but said that that order was ineffective, as it were, against her because she was not bound by it as a non-party. Consequently, she said, you've got to replead and reprove the whole of the fraud claim. So the preliminary issue was set up on whether the 2018 judgment or order could be relied on. And I should say that the claimants accepted at both first instance and in the Court of Appeal that assuming that the 2018 judgment or order were in personam rather than in rem, the defendant was not bound by them. But what we said bound meant in that context is that no estoppel per rem judicatem arose, which could prevent her from raising certain arguments or asserting matters contrary to what was found in the other proceedings. And the position, as advocated by the claimants, was that the fact a judgment or order is not binding on someone does not mean that it has no effect at all, or that its proper legal effects and consequences can effectively be ignored by a third party who would otherwise be affected by them. The Court of Appeal rejected the claimant's arguments. Its reasoning was relatively short after explaining the position, but essentially they said as follows. Firstly, that the rule in the case of Hollington and Hewthorne applied in this case. Now, that rule is a rule of evidence, which most traditionally understood provides that the findings of a court in earlier proceedings cannot be admitted as evidence in subsequent proceedings against different persons of the truth of the facts found or of the accuracy of the decision which has been rendered by the first court. Now, in its judgment in this case, the Court of Appeal considered that the rule did not only apply to the findings themselves, but also applied to the legal consequences and effects of the findings. Now, in doing so, arguably the Court of Appeal decided that a court order which, for example, determines the status of a contract between the only parties to it, or determines as between the only contenders of title, the issue of title, is effectively of no practical effect in relation to any other party who might otherwise be affected by it, even where that party has actually nothing to do with the original case and doesn't contend for a contrary position. Secondly, the Court of Appeal relied on a wider principle of natural justice that a party shouldn't be condemned unheard. Therefore, they said, a non-party to proceedings should not be prejudiced by those proceedings by being bound by the outcome without having been able to defend them as they see fit. And the Court of Appeal contended this was demonstrated by various cases, such as Powell and Wiltshire, in which it was found that a determination of title between A and B as to an aircraft was not binding on person E, who sought to claim title against A subsequently. But the slight difficulty with that, I think, is that it rather assumes that non-party is in fact bound or is being treated as bound by the decision, whereas in our case, that was very much not the position. We were trying to emphasise the distinction between being bound and the question of what effect a judgment or order can have on a third party. And thirdly, although it's unclear to what extent it influenced its decision, the Court of Appeal considered that the 2018 order did not create any proprietary rights in favour of the claimants, on the basis, it seems, that it took the view that rescission was an act of the parties. There is a slight academic and judicial debate about that point, which probably needs to be considered somewhere else. But it might overlook the practical point that, in reality, even if a court order does not create rights, it is often the court order which allows you to vindicate them. So it must have some effect, even if not a creative one. It seems to me, at least, and I don't want to debate the rights and wrongs of the decision. It is what it is, and not least because it isn't possible to do that justice in the time we've got. But I think there are some aspects of the decision which are, or at least need some exploration as to difficulties which might arise legally or practically. The first, I think, is that if the Court of Appeal's decision is correct, then possibly it seems that a consequence is that any time a party obtains an order which might affect a third party, and particularly where that order purports to bestow rights on the first party, the order might turn out to be practically useless when the first party comes to vindicate their rights, because any time they need to do so against a third party, even if the third party doesn't contend that the order was wrong, they could just say, well, I'm not affected by it. So I was trying to think of various examples. You can think of them in legion of different situations, but suppose a dispute arises between persons A and B about title to a classic car, and there's no question that anybody else is the owner of the car. And person A wins the dispute, and is declared to be the owner of the car. And it turns out, unknown to person A at the time, that the car is actually in person C's motor museum. And person C doesn't claim title to the car, nor does he positively contend that anybody else is the owner. He just simply agreed with B that it could be shown in his museum. Now, if person A has to then sue person C for delivery up, or wants to get the car back, can it be right, or is it right, that person C, in response to an action, can sort of shrug and say, well, the order has no effect against me. You have to replead and reprove the same dispute you've had with B, but in my presence, even though I'm not actually taking a positive position that B or anybody else is the owner. Whilst that sort of seems to be the position, it doesn't quite, in my mind at least, sit comfortably in terms of where the balance of justice might lie. If, of course, in that situation C was asserting title, that would be a different case, because that would be the Powell and Wiltshire type competition type of case. And of course, where someone asserts a right of their own, they need to be allowed to have that determination. But that, I think, is different from saying that the order has no effect on C, wherever C does not assert a right to the chattel themselves. Secondly, and more obviously in fraud claims, is the difficulty that victims of fraud might have in pursuing effective tracing claims against previously unknown recipients who know nothing about and can't dispute the wrongdoing or the original fraud. So to take it to a slightly more practical level, suppose that a claimant spends years bringing a fraud to trial, and it's an 8-week trial or something like that, against all the wrongdoers and recipients they can find. Between the trial and judgment, because a different legal position would happen after judgment, but between trial and judgment, the primary fraudster moves large parts of the proceeds of fraud to various recipients who, although innocent, are mere volunteers. The effect of the Court of Appeal decision in this case, I think, is that despite succeeding in the 8-week trial against the original fraudsters, the claimants would face having to replead and reprove the same fraud against every recipient that they subsequently had to pursue to try and obtain the assets. If that recipient was to simply say, well, that judgment was of no effect against me and I can pretend it doesn't exist. And in theory, there's nothing to stop that cycle, I think, repeating itself over and over. There is a potential issue about whether the judgment conflicts with the purpose of seeking proprietary relief in order to pursue subsequent proprietary claims and the nature of a proprietary right. A well-established authority suggests that rescinding a contract for fraud allows the victim to obtain a revesting of the beneficial interest in order to bring a tracing claim. But if in fact you can't rely on the determination you receive to do so, except against someone who's already a party, one wonders what the utility is. And a beneficial interest in property, the Supreme Court has previously said, is or has all the hallmarks of a right in rem. One hallmark of which is that it can be enforced against third parties, save for people like bona fide purchasers for value without notice. But again, actually, if there's a big stumbling block in your way, if you can't actually ever enforce that right in the first place. And finally, I just sort of mentioned that third parties might be protected by other means. I say this because the Court of Appeal acknowledged the existence of Rule 40.9 of the CPR, which provides that a person who is affected by a judgment or order can apply to set it aside. And where that rule exists, one wonders, well, what's its purpose in situations where actually you could just simply say, well, I'm not affected. I mean, the rule commonly in its traditional form was, I think, and Alan will correct me if I'm wrong, used by sublessees, where a head lease is revoked or rescinded. But if a sublessee could simply defend a claim for possession by contending that they were unaffected by a relevant judgment against the head lessor, query the purpose. And if the rule does provide sufficient protection, then does the decision made in this case actually go the right way? So, whilst that position remains as it stands, there are some just practical thoughts I thought I would pass on for all of us who deal in litigation. Firstly, it seems to me more important than ever to try to identify at the outset of a case any parties who might be affected by a decision or against whom a right might need to be vindicated, even if not parties to a transaction or the issue in the case. And it seems to me that, at least potentially, that puts quite a significant burden on claimants and may be impossible in some cases where you simply can't identify where assets are or where people are. The question might also arise in the right case, well, do you need to sue, for example, the fraudster themselves? If the fraudster, the primary fraudster in a fraud claim, is impecunious and the relevant property is located elsewhere, query what purpose the action will serve. I mean, often one assumes that the fraudster still has something, but if they don't, or you don't think they do, is it worth putting the person who is most likely to defend the claim in the frame, if you can, in fact, and if you're going to need to go after other people subsequently. There will, of course, be cases, I think, where it is impossible to identify traceable property at the outset. I should say there might, in certain claims, be opportunities to rely on devices created by the court, such as Rule 19.8A of the CPR, which allows you to bind third parties into decisions subsequently or at the time. But that might not always be the case. So that rule, for example, is limited to trust and property claims, and it's not in every case that that's going to come to your aid. And for those who are acting by parties affected by judgments, there will obviously be, I think, a need to consider what position to adopt in answer to any demand or claim which directly or indirectly relies on some other determination of rights that's already taken place to which your client was not a party. And it calls into question, do you need to apply to set aside a judgment or order, or can you sit back and wait and see what happens? So I think what I would say about this case is, whilst the underlying principles on which the Court of Appeal relied are generally well established, I remain slightly unsure that their extension or application to the facts of this case was necessarily, well, what should I say, was satisfactory. And of course I would say that because we acted for the losing party. But in particular, I'm interested in whether the court's treatment of the rule in Hollington and Hewthorne is correct, and whether it really applies to legal effects and consequences of judgments and orders. But sadly, for me at least, a debate on the legal correctness of the Court of Appeal decision would require quite a lot of time to do it real justice. And that is not for me to say, and it is possible that that might not be the final word. So for the time being at least, that decision represents the law on that particularly difficult issue, and hopefully no one else will come a cropper. Thanks very much.
Thank you, Hugh. I couldn't have put it better myself, and I certainly didn't put it as well in the Court of Appeal. Our next talk is by Heather Murphy, and hot off the press, I think we couldn't say what that she's going to deliver to us, as a result of a very recent decision of the Supreme Court. Economic duress, what now?
Thank you, Alan. And sadly a case which, like everyone else, I lost in, so we shall not break with tradition. I'm heckled from the front that not everybody who's spoken lost. Anyway, some of us lost before the Supreme Court, so I'll live. I'm quite time limited, and this is a very long judgment, and the law of lawful act economic duress. We had a lot of paperwork, so I'm going to limit this talk to hopefully just the practical points that you need to take away. And if you want to ask me difficult questions, wait to the end and Alan can answer them. So, duress. As you all know, there are three common aspects of duress. Persons, the classic, if you, I'll shoot you unless you do something for me, best said in a Northern Irish accent. Duress of goods, I'll restrain those goods unless you do something. And economic duress, which is the baby of this particular category. The elements of economic duress are on the screen: illegitimate pressure, and then really a causation point and no alternative choice. The last two are not really debated within the case law because they're quite... Oh, I need to move on. There we go. They're now on the screen. Thank you. I'm now being helpfully heckled from the front. The last two are just matters of causation and don't really have much academic debate. The real question is, and has always been, what is illegitimate pressure? So when you're thinking about illegitimate pressure, there are two aspects to pressure: the threat and the demand. And so the classic one is, unless you pay me £1,000, I'll shoot you. The demand being the £1,000 and the threat being the shotgun. Or, unless you pay me £1,000, I'll go and tell salacious stories to the press. The difference between those two, of course, is that although both may involve the extraction of money, going to the press is a perfectly lawful act, whereas shooting someone is not. So can both amount to illegitimate pressure? Well, the first thing that the Supreme Court did is conclude, yes, they did. You can make a lawful threat to do something which can turn out to be illegitimate pressure. So the question then is, when does a lawful threat to do something that you're perfectly entitled to do expand into illegitimate pressure? And particularly in the context of commercial parties, because the rough and tumble of commercial negotiations means all parties are free to act in their own self-interest. Why, if I have something that you want, shouldn't I say, well, unless you pay me more, I won't give it to you? That's just how business works. To explain the position that the court came to, it's necessary to look at the background of the Times Travel claim. It was a claim for unpaid commission. The short point was Times Travel were travel agents. In fact, they had a shop into which you could go and buy tickets. They sold tickets on an airline called PIA. Now, it's unlikely that you'll fly on this airline at the moment. It's had its license in this country and Europe revoked because it turned out that about a third of their pilots' licenses weren't legitimate. But anyway, at the time, they were the only people who flew directly to Pakistan. And that was important because Times Travel's customers were Pakistani expats in the Birmingham area. So the original relationship is a customer would go to Times Travel's shop, they would buy a ticket from Times Travel, and Times Travel would buy that ticket from the airline. And they would buy a ticket for £100. Times Travel would pay the airline £100, and the airline would pay the agent £9 of commission. So net, the ticket cost the agent £91. Unfortunately, as the way that things arose, there became disputes about whether or not the airline had paid the commission that it ought to have done so. And a number of agents across the country, over 30, were very unhappy and said that commission was due and the airline were tight and hadn't paid it. And the airline said, no, we changed the basis on which we paid commission years ago. Don't you remember? We don't owe you anything. And as part of these contexts, various groups got together and tried to litigate against the airline. And the airline specifically told Times Travel that if they didn't sue, Times Travel would look after them. Unfortunately, as you can imagine, given this has gone to the Supreme Court, it didn't quite pan out that way. By 2012, the airline had decided to become quite bored of these agents and commissions claims and decided to bring an end to it. And it did so by serving notices on all of their agents terminating the existing contractual arrangements. And they offered all agents, including Times Travel, new terms. And those new terms were commission on a different basis. I'm not going to go into it. That is an entirely separate element of the case that is now en route to the Court of Appeal. So maybe in 3 years I'll be back talking about the Supreme Court decision of that one. But there was a commission on a discounted price point. But the second element, the kicker in it, was that Times Travel had to waive all of their historic claims to commission. Now, that was a claim worth £1.2 million. So this is a sizable claim for a business of 3 people. And in order to make sure that they really ramped up the pressure, notice that the agency relationship was ending. There was only 6 weeks' notice. It was accepted that if the agency relationship ended, that would be the complete destruction of Times Travel's business. And also Times Travel had a credit allowance of 300 tickets per fortnight, so they didn't have to pay up front for those tickets. And the airline cut that to 60, causing them cash flow problems and really reducing what they could do. Faced with the imminent destruction of their business, Times Travel signed the agreement. The litigation was to avoid the new agreement. Now, at first instance, we succeeded. Success story. The court thought the test was set out in Chitty at the time and really was to look at whether or not was the pressure illegitimate, was judged as to whether or not the airline's conduct was substantially beyond normal and legitimate. Slightly circular, but Mr. Justice Warren said, yes, conduct was beyond, yes, economic duress. We went to the Court of Appeal. Unfortunately, they didn't agree. They said the correct test was whether or not PIA had made the demand to waive the claims in bad faith, a very narrow test. Now, PIA had believed, albeit wrongly, that commission wasn't due. There was a good defence to the claim. And so therefore, there was no finding that they'd made the demand of waiver in bad faith, and the court concluded, therefore, no lawful act, economic duress. So we went up again to the Supreme Court. The Supreme Court said that bad faith is not the test, and the Court of Appeal got that wrong, but they still said it wasn't economic duress. So, what is the test? Well, the short point is, it's now a sniff test. The court says, helpfully, you're to look at all the circumstances, and that there are really 2 situations in the case law where a lawful act will amount to economic duress. The first one I'm not really going to touch on. It's a threat to report or prosecute a crime. It's really quite akin to the sort of blackmail situation. The second is where the defendant, having exposed himself to a civil claim by the claimant, for example, breach of contract, deliberately maneuvers the claimant into a position of vulnerability by means which the law regards as illegitimate and forces the claimant to waive his claim. So if we break this down, what is illegitimate pressure? The defendant has committed a civil wrong. The claimant has a claim against the defendant, but the defendant takes steps to cause the claimant to waive that claim, and those steps are considered by the court to be illegitimate. So illegitimate pressure is steps taken that are illegitimate. I think we're unfortunately still in a circular test. So given that we've gone all the way up and the test is now just completely circular, is there anything in the Supreme Court decision that will actually help us when we're faced with a case work out when a perfectly lawful threat crosses the line into illegitimate pressure? And I think the most useful thing that can be pulled from the case is to look at the 4 cases that the court has indicated fall either side of the line and try and work out if there are facts or in that point to what and why it crosses the line. So 2 cases, the court said, yep, lawful act, economic duress, the Borelli and progress bulk, and 2 which are not are CNT and times travel. So looking at them very quickly so you can see what factors might arise. Borelli and Ting, a company called Aki went into liquidation. The liquidators, as all liquidators want some money to deal with the liquidation, and they needed a scheme of arrangement in order to get that money. Now that scheme needed the consent of a minority shareholder and former chairman, Mr. Ting, and Mr. Ting is, in the colloquial terms, a wrong 'un. Mr. Ting refused to cooperate with the liquidators. He refused to approve the scheme. He produced false evidence and forgery. He didn't come across very well in the judgment. But Mr. Ting had the liquidators over a barrel because there was a timeline by which a court set deadline by which the liquidators had to get this scheme of arrangement approved. So faced with the guillotine of the court deadline, the liquidators and Mr. Ting entered into a settlement agreement whereby Mr. Ting would approve the scheme of arrangement and the liquidators would get their money, and the liquidators would not pursue Mr. Ting and his companies. Now, time passed, and needless to say that Mr. Ting's wrongingness came out. The police got involved, there were criminal activities, money was missing. And the liquidators thought that maybe the settlement agreement was a bit limiting, they'd quite like to undo it. So they sought to have it set aside. The court held that this was economic duress. It said Mr. Ting's behaviour was unconscionable, nice certain test, and allowed the liquidators to set the settlement agreement aside and pursue Mr. Ting with the money from the scheme of arrangement that they had got by entering into the settlement agreement. I'm sure Mr. Ting thought that that was quite unjust too. Progress bulk is possibly an indication as to why one ought to trade in scrap metal. The claimants wanted to charter a boat from South America to China carrying scrap metal, and they chartered it from the owners. They had a buyer already lined up in China for the scrap metal and a very fixed delivery date. They got the ship organised, and then the charterers gave the Sankei to someone else. So now they have a lot of scrap metal and no way to get it to China on time. And the claimant was, needless to say, not very happy. But the owner said, no, this is fine. We'll get you another boat, and if there's any loss, we'll make sure that we pay damages to you, which is very decent of them. And the claimant, needless to say, accepted that. The owner then produced the boat, but it was going to be really quite late into China. And so the claimants went back to their buyer and said, look, would you still want the metal, but it'll be a bit late? And the buyer thought, yep, but at a discount. So the claimant, now thinking, right, well, I still need to ship this, goes back to the charterers and say, remember you said about that loss you were going to compensate me for? It's arising. We agreed a charter price. Do you mind reducing it so I don't suffer any loss? And the owner said, no. We'll give you a bit of a discount, but not enough. And the claimants thought by this stage, no doubt, utterly sick of the deal. Fine, we'll just take it. We'll reserve our rights to sue you later. We just need to get the metal to China. Having made potentially the mistake of reserving their rights expressly to the owner then decided to make a take it or leave it option. The only way that they would get the boat was if the claimant accepted that the small discount was all they were getting, and they waived all the claims to the damages. The metal now being very due, the claimant accepted under protest that this had to happen. They then, having got the metal to China, entered arbitration to get that agreement set aside, and the arbitral panel's decision was appealed, which is why we have it reported, and both the panel and the High Court held that it was avoidable for economic duress. And Mr. Justice Cook said the reason why it was because the owner had created circumstances by their own breach and subsequent misleading activity. So the examples were promising the replacement and, I think most importantly, promising to compensate them for damages. So if those are the two that do cross the line, what are the two that don't? CNT Cash and Carry is a case about cigarettes that cost £17,000, but it's much talked about, and therefore its value as a case far exceeds its economic value. CNT had an account with Gallagher, who you may recognise as a cigarette manufacturer. Gallagher were the exclusive supplier of a type of cigarette. CNT placed an order, and unfortunately that order was delivered to the wrong warehouse. Before Gallagher could collect, the cigarettes were stolen. So the question really was, at whose risk were the goods at that point? And Gallagher honestly, but wrongly, believed the goods were at CNT's risk and said, pay the £17,000. CNT disagreed, said we aren't going to pay, at which point Gallagher said, fine, we offered you credit facilities, but we won't give this to you anymore, which CNT felt was very unfair and would be quite detrimental to their business. So they paid under protest. Now here the court said that there was no economic duress. It said that there was no economic duress because Gallagher had made the demand in good faith. As I said at the start, the Supreme Court rejected the good faith, bad faith divide as the reason for legitimate and illegitimate pressure. So there must be some other element about this case, other than the terms on which it was decided, that makes the Supreme Court think that this still is not a case of illegitimate pressure. And then finally, dear old Times Travel. PIA had committed a breach of contract. They'd failed to pay £1.2 million in commission. Times Travel didn't sue because they had been promised they'd been looked after if they didn't. And despite that, PIA sought the waiver of the claim, applied pressure by terminating the relationship, and reduced credit facilities. So why are those two cases not illegitimate pressure when the first two are? Bearing in mind that the test is you must have a civil wrong, D has committed a civil wrong, and D acts in such a way to force the claimant to give up the claim, and that behaviour must be illegitimate, what factors point to whether or not those are illegitimate or legitimate pressure? Now, the court has said some very nice things, but utterly unhelpful, that it must be rare when a case like this will succeed, and the court must be circumspect, and the behaviour must be highly reprehensible, which is lovely, but not very helpful for advising. The factors from the cases, those four cases that come out, that point in favour of illegitimate pressure and illegitimate pressure, I've put on the screen. And so if you look at, if you're in this situation, what might be pointing to the idea that the threat, the lawful threat, is going into illegitimate pressure, are a body of wrongdoing, for instance. So Mr. Ting was committing other breaches of his director's duties when he was mucking around with the liquidators. He was also providing false evidence, which, needless to say, the court didn't approve of. Although what he was doing in a very narrow sense was perfectly lawful, it was against a backdrop of behaviour that the court was really disapproving of. So that body of wrongdoing may well help illustrate that although narrowly the threat is lawful, it's part of a wider scheme that the court's not happy with. Or secondly, misleading statements. Now, there were misleading statements, potentially misleading statements, in both Progress Bulk, we'll pay damages because we can't get you the ship, and in Times Travel, we'll look after you if you don't sue. But clearly, in Times Travel, the court felt that those statements weren't sufficiently misleading or sufficiently clear. And I think, therefore, if you're thinking that the claimant has been put in this position by a misleading statement, you've got to be looking for ones that are clear promises as to what the defendant is going to do, which the defendant then reneges upon. I can see that the problem in Times Travel, a promise that I'll look after you, is really quite vague. What does that mean? Whereas a promise that damages will be paid is much clearer. What factors, if you're in this situation, might point away from the idea that this is illegitimate pressure? Well, unfortunately, I've got to conclude that really it's a monopoly position. Those are the two, that's the factor that unites CNT and Times Travel. In both cases, the defendant was in a monopoly position. Now, the court doesn't really expand on why a monopoly position is a factor that points away from illegitimate pressure. It says lots of nice things about how, monopolies are something for Parliament to deal with and we don't go near it, but it doesn't expressly say why it doesn't relate into the vulnerability. And I think it must be because the monopoly creates a situational vulnerability for those claimants. Both Times Travel and CNT were in positions of vulnerability, not because of anything the defendant had actually done, but just by the nature of the relationship. So it's with this table that I leave you with the sniff test. It will be interesting to see how it's applied, given that actually if you look back over the cases, you can see that at first instance and the Supreme Court, the court was applying a very similar test and came to very different conclusions. And it will be interesting to see what and how the court look at vulnerabilities. I think if you're going to run this, it's going to be very important that from the start you're building a case as to why those vulnerabilities were in place and how the defendant caused them if you're going to succeed. Thank you.
Thank you very much, Heather. Well, I think we're going to finish off today with first Helen Galley and then Nicole Langlois taking us through, is the other way around? Nicole first, and then Helen taking us through some of the more recent decisions.
Good afternoon. I'm going to be looking at two separate questions. The first question is what place loss of a chance plays in the law relating to negligence, where damages are claimed for loss of profit. Sorry, I've got it back to front. I've got it upside down, that's why. And then I'm going to be saying a few words about the recent decision of the Supreme Court in the case of Manchester Building Society and Grant Thornton, which concerned the application of the concept of scope of duty in the tort of negligence. And I'm even more humble than Tim because I wasn't even in that case. So, starting with the question of loss of a chance, just to recap on the relevant principles. These are largely drawn from three cases, which are up on the screen, Allied Maples, Parabola and Vasilio. And the starting point here is that it's important to draw a distinction between the question of whether loss has been caused by the wrong complained of, and secondly, if loss has been caused, how it should be quantified. Now, the fact that there is that distinction is clear, but what's not always clear is how where the line should be drawn. Now, the classic loss of a chance claim arises where the claimant alleges that he or she has lost an opportunity to achieve success. So, for example, in a competition, as in the case of Chaplin, or in litigation. But there's also a separate category of loss of a chance claim, which is known as the Allied Maples type claim. Now, in that case, rather than the claimant alleging that he's lost a valuable right, what he alleges is that he's lost the opportunity of gaining a benefit, albeit one which depends on a third party acting in a particular way. So what's the claimant required to prove in these cases? So in the classic loss of a chance claim, the claimant here has to prove on the balance of probabilities that he has in fact lost the right. So in other words, that on the balance of probabilities, but for the defendant's conduct, he would have entered the competition or engaged in the litigation. Now that's part of the causation stage. But the assessment of the value of that right, i.e. part of the quantification exercise, then depends on the chance of success. But by contrast, in an Allied Maples type case, the claimant is not required to prove on the balance of probabilities that the third party would have acted in a particular way. All they have to prove is that there was a real and substantial chance that he would have done so. And the important point to note here is this is still part of the question of causation, not of quantification. And once the claimant has established that there was such a real and substantial chance, then the next step is to quantify the damages. And again, these would not be assessed at 100% of the value of the benefit, but at an appropriate percentage, having regard to the claimant's chances of obtaining it. So that's the background. But I think an interesting question arises as to whether there is a third separate category of a loss of a chance claim, illustrated by the decisions in Vasiliou and Parabola. Now, given the time constraints, I'm going to focus on the Vasiliou case, but Parabola raised really broadly similar issues. Now, in Vasiliou, the defendant was responsible for causing the claimant restaurateur to cease trading, and the claimant claimed damages for lost profits. Now, what's interesting is that the court in that case appeared to conclude that this wasn't an Allied Maples type case. And this was on the basis, at least at first blush, that the claimant was not seeking to establish, as a matter of causation, that he'd lost the opportunity to acquire a benefit that was dependent on the actions of a third party. Now, in consequence of that, the approach that the court took in these cases to quantification of damages was very different to that undertaken in a typical Allied Maples type case. So the question that the court posed was whether the claimant had proved, on the balance of probabilities, that his restaurant business would have been profitable. And having satisfied itself that the answer to that was yes, the court then went on to quantify the lost profits in the normal way and awarded the entirety of that sum as damages. So in other words, the court didn't apply a percentage discount. Now, the decision in Vasiliou was the subject of a detailed analysis by Mr. Justice Nugee in the case of Wellesley Partners and Withers. And the claimant in that case argued that the court should adopt the Vasiliou approach to his claim for damages for professional negligence rather than the Allied Maples approach. And in doing so, what he was hoping to do was to avoid the application of the discount in the quantification of his losses. Now, on the particular facts of that case, Mr. Justice Nugee and subsequently the Court of Appeal held that, contrary to the claimant's arguments, this was in fact a classic Allied Maples type case, and so that if damages were to be assessed, they would be assessed on that basis. However, having had to consider that question in some detail, Mr. Justice Nugee expressed doubt as to whether, as a matter of strict logic, the differences in approach between Vasiliou on the one hand and Allied Maples on the other could be justified. And the relevant passage from the judgment is on the slide. And in my view, the doubts that Mr. Justice Nugee, as he was, expressed were well-founded, because it seems that it must be right that the profitability of Mr. Vasiliou's restaurant did depend, as his lordship said, on whether a number of third parties would have chosen to come to the restaurant or not. So it seems to me that what the court could have done, in fact probably should have done, was simply to adopt the Allied Maples type approach to the quantification of damages for loss of profit. And this would have entailed the following steps. So as part of its inquiry into causation, the court should have asked itself whether, but for the defendant's conduct, there was a real and substantial chance that a number of third parties would have chosen to come to Mr. Vasiliou's restaurant. And then, as part of the quantification stage, the court should have assessed the damages at the appropriate percentage, having regard to Mr. Vasiliou's chances of obtaining those profits. Now, it's important to note, of course, that it's possible that even if this approach had been adopted, the outcome might have been the same. But that would only have been the case if the court had been satisfied that there was a 100% chance of sufficient customers coming to the restaurant to enable Mr. Vasiliou to trade profitably. And it was only in that case that there would have been no justification for applying a discount. In any event, it seems to me that recognition that Vasiliou was in fact an Allied Maples type case and that the damages claim should have been approached on that basis would help to bring greater clarity and consistency to this area of the law of damages and avoid fruitless attempts to draw distinctions of the type that was sought to be drawn in the Wellesley case. So moving on now to the recent decision of the Supreme Court in Manchester Building Society and Grant Thornton. As I said, this appeal was concerned with the application of the concept of scope of duty in the tort of negligence. Now briefly, MBS was a small mutual building society, and it was advised by its auditor, Grant Thornton, that it could have its accounts prepared by a method known as hedge accounting, and that would be consistent with the relevant regulatory requirements. Now, in reliance upon Grant Thornton's advice, MBS then adopted a particular business model, and what it did was it entered into interest rate swap agreements as a hedge against the fixed rate lifetime mortgage loans that were a central part of its business. Some years later, Grant Thornton informed MBS that its advice on hedge accounting had been wrong, and that must have been a difficult conversation. This meant that MBS had to restate its accounts, and that then showed a substantially insufficient regulatory capital. And in order to extricate itself from that predicament, MBS had to close out the swaps and incurred break costs in the sum of £32 million. And it sought to recover that sum from Grant Thornton in the way of damages. So this raised the question as to the proper application of the scope of duty principle. Now, both at first instance and on appeal, it was held that Grant Thornton was not liable for the costs incurred by MBS in terminating the swaps. However, the Supreme Court held that the loss did fall within the scope of the duty of care and allowed MBS's appeal. Now, the judgment of the majority in this case provides detailed guidance as to the framework within which claims for negligence should be analysed, and so it merits careful reading. But in my view, there are three or four key takeaway points from the judgment. The first is that the court made clear that the need to discern the scope of a defendant's duty arises in all cases concerning professional defendants. So it's part of the law of negligence, and it's not confined to cases involving pure economic loss in commercial transactions. Secondly, it seems that the use of counterfactuals in seeking to apply the scope of duty principle has been reined in somewhat. In the majority judgment, the majority said that this has the potential to confuse rather than assist the correct analysis. And similarly, the concept of what's become known as the Samco cap was said to be unhelpful. The majority also held that the distinction drawn in earlier cases between information cases and advice cases should be dispensed with. Now instead, and this is really, it seems to me, the heart of the matter, what the court said was that a claimant should focus on the need to identify with precision the matters on which the professional person had undertaken to advise, and in light of those matters, to identify the specific risks against which the advisor's duty was supposed to guard. So in other words, the question that needs to be asked is, what is the purpose of the advisor's duty? And then at the last stage in the analysis, what one has to do is to consider whether the loss which is suffered represents the coming to fruition of those risks. And the court said that that was the point of the well-known parable of the mountaineer's knee. So it appears from the judgment that the reason Grant Thornton was held liable was because the Supreme Court ultimately concluded that the purpose of its advice was to protect MBS against the risk that adopting its proposed business model might lead to it having insufficient regulatory capital. And so the losses that were incurred on closing out those swaps, when it was discovered that there was insufficient capital, represented the coming to fruition of that very risk. Now, some will welcome the Supreme Court guidance in this case as bringing clarity to this area of the law. Others, though, are already expressing concern that the judgment goes beyond what was necessary to decide the case, and in seeking to be a comprehensive guide, is vulnerable to being misapplied or misunderstood in future cases. Now I'll hand over to Helen.
What I'm going to talk to you about is something which you'll probably all find terribly simplistic, but I intend to some extent, blow my own trumpet, because that case, Maloney and Mundays, was a case I was in for the claimant, and we won. And some might say, well, that's a rarity. So, but no, it's not the case. It was a case that was a trial that was done remotely, which was the first one I'd done. And I wanted my solicitor in the same room, so she came to stay with me for a week, and she brought her dog. which was quite interesting because it was a puppy and it was slightly incontinent when it arrived, but it wasn't when it went home. So the normal rule for the assessment of damages is, as you know, from Livingston and Rayward's Cole, that sum of money which will put the party who has been injured or who has suffered in the same position that he would have been in if he'd not sustained the wrong for which he's now getting his compensation or reparation. Now, if the transaction is the purchase of something, either a business or land, as it was in the Maloney's case, then the measure of damages is usually the diminution in value at the time when the breach took place. But as set out in County Personnel and Pulver, on the authorities, the diminution in value rule appears to be almost always to be appropriate where property is acquired following negligent advice by surveyors, but that's not always an invariable approach, at least in claims against solicitors, and should not be mechanistically applied. But we do tend often to think of it in mechanistic terms. So while the general rule undoubtedly is that damages for tort or breach are assessed at the date of the breach, that rule should also not be mechanistically applied in circumstances where assessment at another date may more accurately reflect the overriding compensatory rule. So those are the basic principles. They were reinforced in Reeves against Thrings and Long. Now, in that case, the purchaser purchased a hotel where access was by licence only when he thought he got an absolute right over it, and thereafter spent a lot of money in rectifying the problem when it came to light 4 years after the purchase. The purchaser brought proceedings against the solicitors for breach of contractual and tortious duty, and the court in that case concluded there was no liability. But it did consider, on an obiter basis, what the proper approach to assessment of damages might have been, and came up with 3 possible approaches. And they were, as set out on the slide, that you could reimburse the purchaser's entire outlay on the purchase and refurbishment of the hotel, which would clearly have been gross overcompensation. You could apply the difference in value test at the date when the problem came to light, i.e. 4 years after the purchase, together with any consequential claims. And then you could also award the purchaser the cost of rectifying the problem at the date when it came to light. So one significant factor is that they didn't seem to think that assessing damages at the date of the breach was the right approach, but didn't actually come to a decision at all, because they concluded that it wouldn't be appropriate to do so when it was irrelevant to the actual decision, and so left the question open. So then it comes along Oates and Anthony Pittman in 1998, and there the Court of Appeal suggested there were again at least 3 possible approaches to the assessment of damages. There's the difference of value rule, using comparables, or where the property which was being purchased was unusual or being purchased for a specific and special purpose, which the solicitor knew about, or there was a substantial period of time before the defect came to light. The estimated cost of rectifying the defect might be the most reliable guide to diminution in value. And that was a point which I clung to in my rather bold pleading in the Maloney's case. And where the purchaser has managed to extract himself from the transaction he would not have entered but for the negligence of the solicitor, you might get the costs incurred in extraction. Now, the Maloney against Mundays case related to the purchase of a shop which was previously a Budgeon's store in Ascot. And it was a freehold store with a substantial piece of land attached to it, which formed a customer car park, and then also another piece of land at the rear, which was ripe for development and where planning permission had been obtained for residential development. Budgeon's, which had been previously retail and wholesale, had been taken over by Musgrave, and Musgrave had determined that they would be wholesale only, and so wanted to divest itself of over 200 stores, and most of those stores were leasehold, but a few were freehold. And Budgeons produced a whole suite of draft documentation, mostly standard for every transaction, including a business sale agreement, which had attached to it a transfer related to the property, an option and preemption deed, a retailer agreement, and an occupational charge agreement. Each purchaser was to be tied in to Budgeons for its stock for a period of time. There was some scope to amend the standard documentation, and in some cases, and in this particular case, there was some additional documentation, because Budgeons were aware that of the planning permission at the rear. In fact, they'd applied for and obtained the planning permission at the rear, and they wanted to ensure that if it was sold on to my client, that they would be able to take some element of any uplift in value, and so there was an overage agreement for 15 years. It was originally proposed 20 years, but my client got that reduced down to 15 years. So they knew that they wouldn't be able to develop without paying money to Budgeons for the 15-year period, and in fact, during that 15-year period, it would have been uneconomic to have carried out the development. Budgeons also suggested 3 firms of solicitors who might act for these purchasers, all the purchasers, and Mundays were one of them, and Mundays was selected by my client. Now, the fact that the land was freehold was of importance to my client. It was argued at the trial that, of course, it was of no importance at all that it was freehold land. It didn't make any difference to the transaction. In reality, they were paying £2.1 million for the business with the land attached, subject to all the restrictions which were in the various agreements. But there was a valuation by Jones Lang LaSalle, which said that the land, free of all the encumbrances, was worth £3.4 million. So my client was well aware that at some time in the future, when the restrictions came to an end, they would have an asset which at the time of purchase in 2006 was worth £3.4 million and probably worth significantly more than that at the later stage. In all the negotiations, in all the documentation, there'd never been any mention of Budgeons retaining any part of the freehold land in the Ascot title. The draft documentation which had been produced referred to the property being sold as all that land in title number, which was the whole of the land owned by Budgeons at Ascot. When Mundays were retained and produced their report on title, by which time they had seen all the documentation and the fact that attached to the business sale agreement was in fact a TP1, a transfer of part rather than transfer of whole, and that land was to be retained, they sent to my client a report on title with a plan showing the whole of the land in the title, edge red, and asked my client to confirm that that was what they were intending to purchase, and that confirmation was given. In fact, and unknown to the client, the draft transfer which was attached showed land being retained. There was no plan at that stage. The plan came very much later in the day. But the draft transfer included the grant of an express right-of-way over the retained land, which was the access to the car park and the land at the rear. Now, clearly, if, as my clients had anticipated, they were going to get the land at the rear, they wouldn't have needed a right-of-way. The transfer also imposed a restrictive covenant which restricted the ability to develop the land at the rear without Budgeons' consent. The right-of-way was specifically stated to be for access to and egress from the Budgeons' store on the land, and all implied rights were expressly excluded. And Mundays failed to give any advice to their clients about that at all. They never referred to the retention of the land, they never referred to the right-of-way, they never referred to the restrictive covenant. And the retained land was clearly a ransom strip. Now, the transaction took place in 2006, and Maloney's only discovered that the land had been retained in 2017 when they were seeking to sell the store, which had ceased to be profitable, and they were selling it with the land. And they were informed at that stage by Budgeons, in fact, which was by then owned by Booker, that there was a ransom strip, and that they would kindly allow them to have access over that ransom strip while ever the store remained a Budgeons. But of course, Maloney's were seeking to sell to a third party who didn't want to run a Budgeons store, and that if they wanted the land, they would pay for it. And their position was initially they wanted £1.2 million. That was negotiated down to £800,000. The retained land was acquired in 2018, and everything was sold. The shares in Maloney's retail stores were sold on to a third party. Now, the argument which we commenced proceedings on the 29th of July 2019, so 13 years after the purchase. And they were defended, not surprisingly I suppose initially, on liability, causation and loss, and there was a limitation defence. On the 29th of April of this year, which was the day on which skeleton arguments were to be exchanged, and by which time 30 trial bundles had been produced, the defendants admitted liability, causation, admitted liability and admitted that Maloney's did not discover the problem until 2017. So the issues to be determined at trial were simply causation and loss. Now, we argued that we should look at the cost that we had incurred in 2018 in purchasing the land as the best evidence of loss. Mundays said, no. You've got to look at the difference in value in 2006 between what you paid and what the land was worth without the ransom strip. And in fact, according to their expert, that was nil. I think if their expert had been a little bit more realistic, they might have had a better result, but nevertheless. In the alternative to our argument that the £800,000 was the best evidence of loss, which I had pleaded and which my opponent was very scathing about, we said that if it was diminution in value as at 2006, then our expert assessed that at between £420,000 and £617,000. There was a dispute about the construction of the restrictions, and that accounted for the spread. Well, the Deputy Judge, Elizabeth Jones QC, said that it was open to Maloney's because of the length of time between the transaction and when it was discovered, to argue that the best evidence of the difference in value was the £800,000 paid in 2018. Am I on the right page? I think I'm... Yep. Right. So what Elizabeth Jones said was that as a result of the negligence of Mundays, Maloney's did not have the opportunity to rectify the situation in 2006. Had they known of the problem in 2006, they would have sought to rectify the problem, and on the balance of probabilities, Budgeons would have sold the land to them, or would have included the land in the transfer, because that's what had always been negotiated. Had they known of the problem in 2006 and chosen not to rectify it until they decided to sell in 2017, the judge would have had a lot less sympathy with the argument that loss should be assessed in 2017. But they didn't know about the problem until 2017, and so the loss should be assessed at the date when Maloney's were able to and needed to rectify the situation. And to award damages assessed in 2006 would be an artificial exercise and would not satisfy the basic rule referred to in Pulver. She said that if she was wrong, then she would assess damages at £420,000. Now, this was very significant from our point of view because we had made a Part 36 offer of £400,000. And the consequences for the defendant were very significant in terms of interest and indemnity costs. And needless to say, they applied for permission to appeal and failed, although my opponent did try to argue loss of a chance, that this was a loss of a chance case because of the chance of having it, once you found out about the problem, trying to sort out the situation with Budgeons. But he'd never run that argument at trial, and therefore he was refused permission to appeal, and that is now the end of it. But it just shows that you might think that it's quite bold to plead that the measure of damage should, in this circumstance, be what you paid for the land 13 years after the transaction. But in reality, it worked in that case, and it turned out as a very good result. And I do think that it's a principal judgment, and I would encourage you to read it if you haven't already done so. Thank you.
Thank you, Helen. Well, I hope you've enjoyed the address. It does show that the courts have not been completely quiescent during the period of the pandemic and lockdown. They've been operating, as has members of 24-hour buildings. Couldn't help, I don't know whether you got the impression that some of the decisions, such as decisions of the Supreme Court, far from having clarified the law, certainly where I feel, have probably made the law even more uncertain than it was before, which is always great for litigators, always great for the bar, always great for the litigation department of solicitors. Thank you all very much for attending. As I say, I hope you enjoyed it. And your reward now is a little bit of liquid refreshment, which you don't get on a Zoom call, unless you provided it for yourself.